Hey, it's Catherine Franke. It's May 18th, and I wanted to kind of break down the legal process that's being used by lawyers to liberate or free the students who have been put into ICE detention with the idea that they could be deported. We've been pretty successful, except with the case of Mahmoud Khalil, of getting federal judges to order that the students have to be released, pending the litigation around whether their free speech and due process rights have been abridged. Now, Trump is getting kind of frustrated. You know, he likes to get his way. And you can see this increasing in some of the messaging that he's been giving in interviews, but also Stephen Miller, one of his legal advisors, in comments he made last Friday.
Well, the Constitution is clear, and that, of course, is the supreme law of the land, that the privilege of the writ of habeas corpus can be suspended in a time of invasion. So I would say that's an option we're actively looking at.
So in these cases where students have been basically kidnapped off the street and put into ICE detention and then plans to deport them, the lawyers have been able to go to court with the habeas corpus writ and get federal judges to order the government to release these students. And then during the time that they're released, the government would have to prove that they actually have reason to deport them, to justify their doing so, but also that they're not exercising their immigration powers as a way to punish students for exercising constitutional rights to political speech and action. So this writ is fundamental to democracy. It's a check on excessive executive power, and Trump is frustrated that these students have been released, and it's frustrating his project to deport all of these students whose views he doesn't agree with.
I was elected to get him the hell out of here, and the courts are holding me from doing it.
But even given those numbers that you're talking about, don't you need to uphold the Constitution of the United States as president?
I don't know.
And so he is cooking up a way to what's called suspend the writ of habeas corpus. So the Constitution allows for this. There's language in the Constitution that says that the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. So this appears in the Constitution in Article 2, which deals with the power of Congress. And even though that language doesn't mention that it's Congress that has the power to suspend the writ, that's the common and widespread understanding, is that if they thought that it was the president who had the power to suspend the writ in the case of invasion or rebellion, it would have been in Article 2 of the Constitution, which has to do with executive or presidential power, not Article 1, which has to do with congressional power. So the writ can be suspended, which means in a case of an emergency, a national security emergency, basically our civil rights are suspended. This has happened 4 times in U.S. history. The first was President Lincoln during the Civil War suspended the writ of habeas corpus during the rebellion, the Civil War. He did it on his own, but Congress then later promptly ratified it with legislative action and reinforced the idea that the president can't suspend the writ of habeas corpus on his own. The second time was in 1871 during Reconstruction, when the Klan was meting out all kinds of racist violence in the South, and the writ was suspended in 11 counties in South Carolina in response to that Klan violence, so a kind of rebellion that posed a serious threat to the public safety. The third time was in 1905, when 2 provinces in the Philippines were in rebellion, and the writ was suspended there. And then lastly, right after the Pearl Harbor attacks in Hawaii, the writ was also suspended as a kind of emergency measure during an invasion that obviously threatened the public safety. Notwithstanding everything I just said, it wouldn't be surprising that President Trump would decide, you know what, I'm just going to interpret the Constitution in the way I want.
But there is one way that has been used very successfully by 3 presidents, all highly respected. And hopefully we don't have to go that way, but there are ways of mitigating.
And he's been saying this recently, is that, do I owe any kind of loyalty to the Constitution? I don't know. So if he were to suspend the writ without congressional action, and then say that those federal court judges no longer have authority to release our students, what would happen? Well, it would be challenged in court, and interestingly enough, it would make its way up to the Supreme Court. One of the national experts on the writ of habeas corpus and on the lack of presidential authority to suspend it is none other than Amy Coney Barrett, who wrote about this issue when she was a law professor at Notre Dame Law School, published a long article about it in the Cornell Law Review, and she was abundantly clear that it was an important part of shared, separated government and checks and balances in our constitutional system, that the president cannot, on his own authority, suspend the writ and then deny due process and other constitutional rights to people that he doesn't like. So on the level of can he do this? I don't think so. And if it goes to the Supreme Court, Amy Coney Barrett's going to keep it from happening.